Okay, good evening, everyone. This is the first lecture of two lecture series that I'm going to be posting, and the objective of which is to cover our material for the course for the first week. My name is Amr Kandil. I'm your instructor for CE 524. I'll be looking forward to meeting you and getting introduced to all of you. But before we actually go into the class, I want to actually go through a bunch of policies and procedures that you guys can see in the syllabus I've already posted online on our Blackboard page for the class. And I want to start off with just discussing our exams and our grading. The classes had always two exams, 25% each, representing 25% each. We also had a final project that has 25% weight as well. We have usually around two assignments, and that carries a weight of 10%. And in class participation, we actually have a load of 15% on it. And the reason that we have that much weight on it is that we'll have, as you see, we'll have a bit of interaction in the class that requires you to show up and to be part of a group and actually participate in activities. So on top of those 15% class participation, you actually stand to win another 15% by way of bonus, depending on your performance on those activities. So we basically have a competition, and we basically stand to earn about 15% in bonus. It could be more or less depending on how things go and how much people are earning by way of points in our competitions. And then these are kind of my tentative grades. You can see that my A is usually a 92% or above. That tends to adjust, but if it does adjust, it will adjust downwards, not upwards, to allow more people to get more, to improve their grades. And you can see the rest of the grading scale, and as I mentioned, it's a bit of a flexible grading scale that adjusts in your favor, not never to your disadvantage. Now, some of my own expectations of you in the class is that I expect you to uphold academic ethics to its highest. That means that I'll be expecting you to not plagiarize. I expect you to not copy from each other in exams. And I basically don't really police that very hard because I have very high expectations of you as future professionals and members of our profession and colleagues. So, but in case I do find someone who is unfortunately committing such an act, an unethical act, academically unethical act, I basically be reporting them and taking full measures required for to do basically to handle the situation. So I hope I never get to that. I'm fortunate I've never been faced with that, but please kindly don't put us into that situation. And of course, I have my full trust, and I hope you never lose that. I expect us also to deal with each other and with our colleagues in class with the highest level of respect and professionalism. As I mentioned, I do regard you as future colleagues, so I will treat you as such. I expect you to treat each other as such and to be very highly professional. That also includes us to talking about group work and collaboration. So as part of your professional conduct, I expect you to be able to carry your own weight in class activities. I also expect you to participate to your group as effectively as possible, and therefore I basically don't want you to I don't want to have hear about issues in that regard. Um, and I will hope for us to have a very smooth semester in that regard. But I want to just let you know that I see it as my role to basically make sure that everyone upholds that. I'd like to know of any issues within your group dynamics, because and once the groups are formed, you're basically going to be working with those people until the end of the semester. And I'd like to know of any issues that you may face by way of academic and academic conduct, and therefore, or basically issues with group dynamics, and I'll make sure to mediate and try to solve those problems as best as I can. So for today's lecture, which is titled Contracting Overview, we have a bunch of learning objectives. These are going to be actually split over our first two lectures here in class. They all come from the first chapter that's been posted in your section 1 reading that I already again posted on your Blackboard. The learning objectives are first to understand contract classifications in different types of classifications that exist for construction contracts or for contracts in general. We also have a very important concept that is called mutual assent, which we'll go over and define and have a bit of a better understanding of. And that will basically cover the first lecture video that I'll be posting. But beyond that, the remaining three objectives here are going to be subject of our next video. So we basically have we'll go ahead and try to comprehend what defects could exist in mutual assent, and we'll basically try to go ahead and understand consideration, which is again what people exchange by way of benefit in terms of the contract, and how is that a contract requirement and whether it's a contract requirement or not. And then finally we need to go ahead and also understand something called the writing requirement and the statute of frauds, which basically is an old English law that still has some effect in our life in the way we conduct contracts here in the United States. So these are the main topics. As I mentioned, we'll cover the first two right now, and the remaining three are going to be the subject of our next lecture video. So to start off, let me just go ahead and ask you this, and ask you to contemplate. And had I been in class, we would have had a nicer discussion about this. But let me ask you this: so why do we need to know about contracts? So why is it that we need to know about contracts? And the simple answer to that is that we basically enter into contracts every day of our life. We enter into contracts when we purchase a piece of software and they ask us to accept their licensing agreement. We enter into contracts when we set up utilities for our new apartments. I know many of you are new students and they just moved into town. And we basically stand to make or lose a lot of money based on our knowledge of contracts and how contracts work. You basically can have rights that may be lost by the fact that the contract is not enforceable. You can actually have obligations that imposed on you, although unexpectedly, because contracts are enforced in a certain way that you didn't understand. So therefore, it's really important for us to understand about contracts even on a personal day-to-day life. From a broader perspective, we need to understand about contracts because contracts are very important tools for us to conduct transactions in an economy. They basically allow for us to conduct economic exchanges and to have productivity overall in the economy, because manufacturers can sell their goods and make sure that they get paid for them. People providing services such as transportation services are capable of getting paid based on their work, and therefore it keeps them in business, keeps them working, and basically provides legal sanctions that we need to take performance. So whenever you go into a contract, you basically have some way of enforcing your rights and for the other person to enforce the responsibilities that you owe to them. It also gives us some autonomy. So one of the concepts that exists in American law is the concept of the freedom to contract, which says that you basically have the freedom to enter into contracts with whomever you want for whatever subject that you want, as long as that subject does not break any other laws. So, for example, you're free to contract as long as you're not going to contract for someone to rob someone for you or to commit some other type of crime on your behalf. So these are going to be illegal contracts. So the only restrictions for freedom of contract is one of those main is just the restriction of legality, and it's definitely an understandable restriction because you'd be committing a crime anyway. So you don't want to. The law doesn't want you to allow you to conduct such a behavior or to go through such behavior. Now, let's start entering into the different types of contract classifications. So first of all, we have two types of contracts. So basically, you can specify contracts to be different, or they could be classified along the lines of whether they're implied or express. So what do you mean by an implied contract, and what do you mean by an express contract? First, an express contract is a party where it's a contract where parties do manifest their assent or their agreement by oral or written words, and it's something that is it's open. Like we have an agreement, and that agreement is explicit and restated in either written or oral words. So basically, you can have an agreement that, for example, your next door neighbor is they have a teenager who's basically going to mow your lawn. You don't really sign it, but you have an agreement, and you have an agreement on how much it's going to cost you every time they go ahead and mow your lawn, and you know exactly how much it's going to cost you. So that's an example of an express oral contract. When you enter into a contract for your apartment, it's another express contract, but it's actually an express written contract because you sign a lease. And the lease is has a certain date at which it starts and has a certain date at which it ends. And you basically have another express contract there. That's also, but this time it's actually an express written contract. Now, on the other hand, we basically can have something called implied in fact contracts, or just implied contracts in fact, implied contracts for short. And in this case, our assent is actually manifested by acts rather than words. So, what would be a good example of that? So, let's assume that without any prior agreement, you find your next door neighbor's teenager. They mow your lawn, and every week you basically you give them a check, hand them a check for, let's say, $50, $60, and this is something that you've been doing all over your summer season when grass is growing and you basically need to mow lawn. You basically, in this case, you actually have a contract that you're putting into place, and it's not an oral contract even, because you never discussed the matter, you never had an agreement of any sort, and you basically have created a contract that's implied in fact, just implied by your actions. Now, when does this get to be an issue? It gets to be an issue when you basically have a case where you have an implied in fact contract where you don't want to make payment on your contracts, or one party doesn't want to meet their obligations by contract. And a good example of that is the next case that we talk about, is where we have the case of the United States versus Young Lumber, where you basically have an employee for a subcontractor. They had actually rented a piece of equipment, and this piece of equipment is a replacement for another piece of equipment that was provided by a third party. The piece of equipment was used and on the job, and it was basically benefited the subcontractor. They got paid for the work, but in the end, the employer, which is the subcontractor here, refused to pay their employee on basis of the absence of an express agreement. So they said that we never asked you to do this. You just rented this piece of equipment and never asked you to do it. So basically, we're not going to pay you for it. And in this case, the court did rule that the actions of the parties did create an implied contract. So though the country, although that person was supposed to be was really never discussed this matter with their employer, and they never sought permission to go ahead and rent a piece of equipment. However, since the piece of equipment was there and the presence was known, the usage of it was known to the employer, they basically have therefore created a contract that's implied in fact, and that's what the court ruled. Um, Unless there are certain types of agreements that we see when we talk about the statute of frauds and the writing requirement, unless those agreements are required in writing, we actually courts can find an implied in fact court and contract, and they basically can enforce such a contract, and they would consider such a contract to be valid. The only case is that when we have a case that the law says in order for you to have a valid contract, it has to be in writing, which is what we call the writing requirement. And we'll discuss those cases in the next lecture video. Um, so Next thing is we need to look at other classifications of contracts. So another type of classification is contracts that are classified by the subject, and they usually could be classified in one of those following cases: the sales of land, the sales of goods, loans of money, leases, service contracts, professional service contracts, insurance contracts, and family contracts. And although many contracts appear, or contract law appears to be really unitary in the United States, and it appears to be treating all contracts the same, there are many common aspects of different contracts. However, different contracts do receive different treatment by the law. And an example, example of that is, for example, a sales of good contract is held to a standard, legal standard that's called successful outcome standard, which creates something called an implied warranty of fitness, which basically says that if someone sells you a good that's supposed to function in a certain way, they are held to the standard of having it work in that certain way. So they're not supposed to be selling you a piece of equipment, for example, a lawnmower that doesn't work, for example, that doesn't really cut grass, just makes noise and doesn't cut grass. So that's actually there's a standard of successful outcome, that they sold you a product that works the way they said. And this basically creates what we call the implied warranty of fitness. And in cases of service contracts, they're held to a slightly less level or slightly lower level, in which they basically have to show that they exhibited the effort to provide you the service, but they're not really necessarily going to guarantee the outcome, the successful outcome of that process. Now, another classification of contracts is something called the classification based on whether they are bargain contracts or what we call contracts of adhesion, or negotiated versus adhered to contracts, or negotiated versus contracts of adhesion. The first one, which is basically what we call negotiated contracts, is basically, or let me go ahead and show you this. So basically, have contracts can be classified along those lines, and let's look at examples of what we talk about, what we mean by negotiated versus adhered to contracts. A negotiated contract is a contract in which two parties have equivalent bargaining power, and they enter into a formal negotiation that has give and take. Parties are able to modify the terms of the agreement, and they're able to have some input of what terms they want to include, and based on that they work out a mutually satisfactory agreement. So the question is, aren't all contracts supposed to be like that? But the answer is they're supposed to be, but in reality and practically they're not always going to be like that. So let me give you an example of a contract of adhesion that we all enter into, or many of us enter into, which is your contract with your cell phone provider. You basically are handed down a contract that you basically have very little bargaining power. You can basically go tell AT&T or T-Mobile, whoever the carrier is, that I want my monthly rate to be $20, and this is what I'm going to pay for that much minutes and for that much messages, and that's what I'm willing to pay. They basically have no power of bargaining. It's their service they provided to you. You basically have no weight to go ahead and negotiate a contract, and you basically have the terms of the contract handed to you. You basically can't change much into them. You basically are provided with this printed form of contract, which we rarely read, unfortunately, but we go ahead and basically sign it anyway, and that's a contract of adhesion. So again, a contract of adhesion in this case is a contract that has no or minimal bargaining. So basically has very little bargaining. You can't go ahead and negotiate your situation. It has a party that's dominant, that hands down a contract to the weaker party, and it's really on a take it or leave it basis. So you can't say that, yeah, you know what, I'm going to change this particular article. You can't do that. It's either take it as a whole or leave it as a whole. And in this case, you as a weaker party have to accept all the terms. Now, Why is it important for us to distinguish between negotiated contracts and contracts of adhesion? It's really important because in cases of ambiguity in the contract, um, who do you think is probably going to be the party that will be more suspected in cases of an ambiguity? It's probably the party that was dominant, that handed down the contract to the weaker party and didn't give them a chance to negotiate. So any ambiguity will be probably interpreted against the dominant party, against the party that created the contract. So basically is an important reason to understand. Um, so the important caveat we have to make here is that some contracts are not necessarily all going to be contracts of negotiated are entirely negotiated or entirely adhered to. So there are some cases where we have articles or parts of the contract that are adhesion, are a form of adhesion, while others are negotiated. And sometimes the adhesion contracts are accompanied with by a monopoly of power. So sometimes, for example, you have no choice but to go to this provider of the service. Like for example, if you're signing up for water in your house, and the water utility that exists in your area is just a single provider, so they have this monopoly, the power of monopoly, and they basically have you have no choice, you have no other alternatives in the market. So in those cases, in the cases of contracts of adhesion that exhibit some of that, as I mentioned, the courts would basically interpret ambiguous terms against the stronger party in the negotiation, which only makes it fair, of course. And then legal rules usually seek to determine any reasonable expectations of the weaker party and try to enforce them. So I mean, let's say for example you sign a contract where you expected not to use your cell phone on weekends, and of course everyone uses their cell phone more probably on weekends. So the legal rules here say that if you had not if you had been aware of this contract, you probably would have. This is not your expectation, right? Your expectation is that you're free to use your cell phone whenever you want. So in this case, if there's a conflict about this particular term, the legal rules would seek to determine what would be your reasonable and likely expectation. And even if you're not aware of the term at the time, you basically may find that the court will help you get your expectations, your reasonable expectations achieved. The terms of adhesion are also more likely to be found unconscionable. So what do we mean by unconscionable? Unconscionable terms of a contract are terms that shock the judge's conscience, and therefore are unenforceable. So we'll talk about this unconscionability as one of the defects to mutual assent, and we'll talk about that in the next lecture video. But for now, one thing that's important for us to stress is the fact that there are contracts that may be negotiated, may be arrived at by complete approval and assent of the two parties. However, these contracts are still not enforceable, or parts of those contracts are not enforceable because they are so unjust, they are so unfair that that the courts cannot enforce them because they shock the judges or the court's conscience. And in many cases, terms of an adhesion contract would be more likely to be found unconscionable, since again they're handed to you, you have no negotiation power, and therefore you're more likely to accept this. You're forced to accept something that's unfair. So sometimes the court would be willing to find those terms to be unconscionable easier than other contracts. Now, the next part of this lecture will basically move on to understanding what mutual assent is, and we want to understand how does it work, how does it get expressed. So in every contract, what we need to determine, or what contract, if you ever get into dispute and go to court, the court needs to determine whether a meeting of the minds has happened in order for it to determine whether a valid contract does exist or not. Now, and the idea here is that each party should be basically knowledgeable, know basically that they have entered into a contract, They should believe that they entered into a contract. The parties should be also bound by what they manifest, even if they have different intentions. So, for example, if I basically express to you the fact that express to you an intention to sell you my car, and after a while I have to negotiate and acted in some ways. For example, you rejected other offers for cars that were offered to you, and you come to me and say, you know what, I wasn't really serious. I basically was joking. So basically, what I expressed by my actions, what I manifested by my actions, is really what binds me even more than what I mean. My hidden intentions are really relevant because what I manifest is what's important here. So as I mentioned, what if the question is, what if one party was just joking? Should they be held to the agreement? And the answer, it depends. If this joking sort of did not cause you any harm, didn't cause the other party any harm, then basically the contract may not be enforceable. However, if it did cause some harm, or they basically went ahead and incurred some cost based on that, it basically is going to be probably a bit enforceable. Okay, so what is mutual assent really? Mutual assent is basically expressed in something called offer and acceptance. Um, so in an offer and acceptance process, we have to have some form of communication between the parties, typically oral or written, in which they express their offer and acceptance. We said that that's not necessarily the case in cases of implied and fact contracts, because the mutual assent, the offer and acceptance, can be expressed in actions. So the offer would be someone doing your lawn, like mowing your lawn, and your acceptance would be letting them do it, and the cost that basically will cost you is how much you actually pay them. So this is again something that it's not necessarily a requirement for a contract, the fact that it's communicated, but in general there has to be some form of offer and acceptance. In case where we have an express contract and the parties are reaching the agreement at the same place, we rarely need to have to demonstrate the fact that the offer and acceptance has actually happened. However, the problem arises when we actually have parties that are distant, parties that are not co-located, and the distance requires us to have some demonstration of that they have reached this agreement, the offer and acceptance, and whether the offer and acceptance happened in a timely manner, whether it happened at a certain point of time where they were supposed to happen. And we'll see the different intertwined issues there, because when we send an offer, when do we consider an offer to be sent, and when someone sends you back an acceptance, when do you actually consider it to be received? So that's these are two important questions, and we want to also make sure that we have a clear distinction between an offer and a negotiation process. And the question I have for you guys, and I want you to think about for a moment, is how are they different? So how is an offer for a service, for example, is different than a negotiation that we're going through? So think about the cases where you're going ahead and buying a car, and you have a salesperson that's trying to convince you to sell the car, and they basically, for example, tell you all the things about the car, and they start describing it to you, and you basically don't have any firm discussions about the financing and about the money and the numbers yet. This is probably more of a negotiation. However, once we start talking about the numbers and the person produces a number for you and says, this is how much I can sell you the car for, they actually have given you something called the power of acceptance. They say, okay, deal, I'm buying this car. If you just write a check, car is yours. You basically have accepted an offer, car is yours. So once someone makes you an offer, they give you something called power of acceptance. And this power of acceptance is something that you have while the offer is valid. And we'll talk about the validity of the offer and how long it lasts and stuff like that in just a few moments. Okay, so in order for us to distinguish between a negotiation and or a proposal versus an offer, we basically have to look at the language which is used much more clearly. So one of the things that is required of the language of an offer is something called the certainty of the terms. The certainty of the terms means that we basically have to have very clear terms that say this is what I'm providing and this is what I'm expecting. So in an offer, you basically have to say this is what I want and this is what I'm expecting in return. It also has to have um, it has to basically have to indicate if the proposer will perform any future action. So, for example, if it's an offer where it says that the estimate of this cost is so and so until I further elaborate on the cost and study so and so. So there's a difference there. It's basically not an offer because it's not certain yet, and it also indicates that the proposer or the offerer is still going to perform further actions in order for them to verify the offer or make sure that this is the final solid offer. Another indication that we look at is not just linguistic, it's also the past dealings. The past dealings of those parties is in the past have they created contracts on offers that were worded as such and were they considered the offers and accepted and basically they led to the creation of a contract or not. It also depends on the persons to whom the offer is made, and is it really a person that has the ability to make a decision, or is that person still not the ultimate decision maker, and they basically have to go ahead and take the decision to higher ups. The question is, what happens? There's a very important question here. What happens with a proposer negotiating multiple parties? All of them know. So, if I, for example, have this car, it's kind of a rare exotic car. So many people are interested in buying it, and I'm actually negotiating with multiple people over the terms of the sale, mainly the price of the car. And the other parties know that there are competitors that are out there that are looking at buying this specific car. The idea is that in this case, when we enter into negotiation, we start talking about the money, and you know that I'm talking to others, basically as the owner of this car. You know that it is more likely that the communication that we have is the communication is not an offer, so it's not very likely that it's actually an offer. The likelihood of it is less. It's more of a negotiation. If you basically know that it's only you and they basically are telling you this is what I'm expecting, you probably know it's more likely that this is really an offer, not really just a negotiation process. The next question is, and which is a very important question here also, is are offers revocable? And the follow-up question is, when are they revocable? So can I make an offer and decide that I'm not gonna go through? I just can't go through with those terms. I really need to back up on this deal. And the answer is, what do you think? What's it gonna be? Is it gonna be yes or no? And when can we do it? Okay, so again, absent from being away from past, I can't have you guys have a discussion about this, but at least food for thought. Common law basically has concluded that all offers are revocable even when we state that they are irrevocable. However, there's a caveat to this. The caveat is when. So in general, offers could be withdrawn or revoked directly or indirectly, and you basically have to do that before acceptance. Once someone accepts an offer, you enter into contract, and there's no way for you to revoke a contract. Their offers, the offers that you made anymore. The rule for revocability, however, has a number of exceptions. The most notable exception of them is the one that in which we have something called reliance. So, for example, someone has relied on the offer that you made for buying the car, for selling them the car for a certain price, and they wanted, for example, and build them a nice garage that's attached to their house or whatever, this is an act of reliance that's based on the offer that you made to them, and therefore the revocability of the offer is questionable. Basically, another exception is the case of sale of goods, where offers are revocable for a stated amount of time, or for a reasonable amount of time. So it could be for example, an offer would be revocable for a month, or for a reasonable amount of time. And the reasonable amount of time is really depends on the nature of the good itself, the nature of the contract. So if you have an offer for someone selling you stocks on a stock market, then this offer is going to be probably more volatile. It's going to be more. The reasonable expectation for you to answer is basically shorter than if someone has maybe an offer to buy, for example, their car. Another example is when you have a case where you have someone selling you a durable good versus someone selling you a perishable good. So if you're buying a crop that's perishable, you basically have a shorter amount of time to accept an offer, or a shorter amount of time during which the offer is revocable versus the amount of time that you have for the acceptance period will be longer for a durable good. And then, okay, so offers would be also valid, as I mentioned, for a certain amount of time, which is the acceptance period. And what happens after that period? Again, the offer doesn't exist anymore. And when does the period start? Again, it starts when the offer is made. But the question is, when is the offer is made? And we'll discuss this after just a short break here. You guys don't mind. Okay, everyone, welcome back. So I basically, before the break, I was talking about offer and acceptance, and when are offers revocable, and when does the offer period end. So basically, many offers come with no stated duration. So basically, you get an offer that doesn't say when does it start and when does it end. And whenever such a case exists in a contractual situation, a standard of what we call reasonable time is employed. And this standard is, as I mentioned, varies depending on the subject matter of the contract itself. So remember when we were talking, we said that, for example, a contract for a perishable good is definitely going to have a smaller offer acceptance time or acceptance period than a contract for a product that it's a durable product. It's a product that doesn't have an expiration. It doesn't have to necessarily be used or consumed by a certain date. Any offer that basically is revoked has to be communicated to the offeree. So in order for you to have an offer revoked, if it's not timeline, so if an offer that doesn't have a specific period of time is revoked, it actually has to be the revocation of the offer has to be communicated to the offeree. And another method of terminating an offer is if the offeree gets basically rejects the offer. So if basically there's a rejection of the offer, it basically also ends. Any rejection to an offer could be either a direct explicit rejection, or it could be rejected by a counter offer. So this is something you need to be very careful of. So if someone makes you an offer, let's say an offer for employment, that offer gives you the power of acceptance. You can basically go ahead and accept that employment offer. However, if you go ahead and present them with a counter offer, you basically have implicitly rejected their offer, and you basically have created the counter offer is basically now they've become the offerees, and they basically have the power to accept your offer or not. Any acceptance or rejection or revocation of the contract of the offer basically has to be communicated to the offeree, and revocation has to be communicated generally in the same means of communication that the offer was accepted by, was sent by, in order for it to be valid, the revocation to be valid at the point of time when it's sent. We also have to communicate the acceptance back to the offerer, and the acceptance has to be unequivocal. It has to be very clear and it's not wavering in any way. And it also has to be an offer that does, an acceptance that does not propose any new terms. And here we actually bring up something called the mirror image rule, which says that your acceptance of an offer has to mirror exactly the terms of the offer. So this is sometimes an issue when you basically have large companies that have standard letters that they send in response to certain situations, and those letters may actually differ from the terms of an offer made to them by, for example, a material supplier or a subcontractor. And in such a case, if there are differences between that standard letter sent by the company and the offer itself, sometimes that may be ground the offer not to be really accepted, because it does not really mirror the offer that's been made. So in such cases, and some courts actually have given the offeree some leeway, and would actually be looking at the differences, and would be looking at them if the differences between terms of the offer and the acceptance are significant, then that may be grounds for considering that the meeting of the minds in the offer and the acceptance is not happening. However, if the terms are significantly similar, then the minor differences may be considered to be subjects of change to the contract or changes to the contract, but it will be at least the main core of the offer has been accepted. But in general, in order for you to have no doubt, then the offer and acceptance should be exact mirror images of each other. So the terms of an acceptance have to mirror exactly the terms of the offer. Okay, so what happens in cases where we are creating contracts by correspondence? So we basically have contracts that we are setting up between parties that are not in the same location. Here we have to also look at a couple of caveats. Again, a couple of things that we have to look at. And the main question is, when does offer and acceptance happen? And the main question is, so when does an offer happen? Does it happen when we send it, when the offer is sent, or when it's received? So that's the question. And the same thing applies to acceptance. When does the acceptance happen? Does it happen at the point of time when it's received, or when it is actually sent? And here we basically have a rule that we call the mailbox rule, and this mailbox rule says the following. So in general, the first thing is that an offer is considered to be in place once it's received by the offeree. An acceptance, however, is considered to be in place, or we already have accepted an offer, once that acceptance is sent back, the moment it gets sent back, provided that you are using the same mode of communication by which the offer has been made. So let's say, for example, the offer has been made to you by FedEx. Someone sent you a FedEx that's, for example, next day delivery, and they basically sent you the offer through that. In order for your acceptance to happen the moment you send your offer, it basically happened. You have to use the same method of communication, which is again FedEx next day delivery. And of course, there are a couple of other things. So, for example, let me just reiterate. So, if the offeree uses the same mode of communication, and they actually have the correct address and postage. So let's say you're sending back the acceptance by mail, and for example you sent it to a wrong address, or you sent it to an address and you didn't put enough postage, which led to the letter being returned to you. That is, these are all void. These all basically just don't make for the mailbox rule to apply. The basic mailbox rule ceases to apply at that point. Acceptance will be effective once it's placed in the mailbox if those two conditions happen, and this is what we call again the mailbox rule. This only applies if the offerer did not require the communication to be actually received. So sometimes the offerer would say in the offer itself that we basically expect the acceptance has to be received at a certain date. So basically, you could set a certain date, and you could set the requirement for it to be received at the business address of the offerer. In that case, and you put that clearly in the offer letter. If that's the case, then you basically have the mailbox rule would also not apply. So mailbox rule would not apply if the offerer has requested that the acceptance will be received by a specific date at a specific address. Okay, so another important act for asserting the existence of mutual assent is what we call reasonable certainty of terms. So basically, one thing, why do we require certainty of terms? What do we mean by certainty of terms to start with? So certainty of terms means that there is no doubt about the terms of this contract. There would be no doubt about the specific details of it, the exact service being provided or the goods being provided, the exact amount of money that will be required in return. So this has to be clearly stated unequivocally in the contract itself, and this is basically a test for the offer, for an offer, and it basically tests how clear and complete the terms are. And the less certain terms, if you have terms that are extremely uncertain, one of the things that you have is basically the doubt that you're actually still in negotiation. So you may be still in negotiation if you do not have clear certainty of your terms, and there's a bit of uncertainty there. So a valid contract would again rely on the certainty of the meaning of the terms, and the question is, why would certainty be required? A couple of reasons. First of all, if you basically are if your terms are still unclear or vague, this may be an indication that you're still in negotiations. It may be an indication that you still have not reached an agreement, and therefore you state what the terms of the agreement are. So therefore, this is one reason. The other reason is basically that a judge should be able to clearly determine whether the contract has been performed or not just by reading the language of the contract. So just by looking at the contract itself and reading the details of it, they can actually determine whether the obligations have been met by the parties and whether the rights of the other party have been received or not. So basically, it has to be clear to the judge. The term reasonable in many legal contexts indicates that it's not really clear-cut what reasonable time is, reasonable certainty is. It's actually a matter of judgment that can be left to the court to decide. But in general, reasonable certainty indicates, again, that you don't have to be 100% clear, but you have to be significantly clear to the point that a judge can, again, determine whether you've achieved the goals of this contract or not. There's the lead marking case, or actually a case that you find in your readings, which is a case by Jansen versus Philip, and it's the case again of a landscape architect who basically promised to landscape a property for its owner, and they basically started off with an agreement where the owner wanted a very high quality job. There were billings in the middle, and that resulted in a letter from the landscape architect saying that they are willing to, quote unquote, substantially landscape the property for an amount of $6,500, or nearly so. So actually, this is the court to us the contract is in place, and they may be still in negotiations, although there may be some performance going on. But the idea is that there was the terms substantially and nearly so in the language of a contract or language of an offer actually is an indication that there may be less than the terms of the contract may be less than certain. That there may be some uncertainty in the terms of the contract. Okay, so let's move on to again to mutual assent, and here this is the last few slides on mutual assent here. We want to talk about the writings or documents that may be used for showing mutual assent. We want to show what are those different types of documents and whether those do actually reflect mutual assent or they don't. The first one is what we call preliminaries. It's a general class of documents. They are really informal writings. They are labeled as preliminary or tentative agreements, or sometimes they're also termed purchase orders. The parties do expect, in such a case, they do expect the execution of a more formal writing to follow. They expect like a full contract to be drafted. And the question I have for you guys is this binding or not? Okay, and the answer is not really clear cut. The answer is actually it depends. It depends on the intent of the parties. So if we basically have a complicated transaction, so let's say for example you're drafting a letter of intent or a tentative agreement for purchasing, I'll go extreme here. Let's say you're purchasing a nuclear reactor that's basically produces electricity for half a state, for example. That's really a complicated transaction. It's really a very complex thing that you're buying there, and a tentative agreement is not sufficient. So in such a complex transaction, the answer would be no. If you basically have performance starting, it's simple enough, and you have performance already commencing, then actually sometimes it would be sufficient. And if performance is only by one party, starts by only one party, then that creates ambiguity. You don't really know whether it's a full binding agreement or not. Many modern courts now actually try to find contracts in the earliest possible writings, in the most early of preliminaries, and that happens if it's convinced that the intent to be bound exists by the two parties, and the only what's left is just minor gaps that exist, and sometimes they basically would basically fill the gaps based on what they perceive to be the intentions of the parties, or what they know, or basically based on expert witnesses or based on expert testimony that these are the norms of practice in this industry or in this particular type of transaction. So this is something that happened in an actual court. Another type of writing that is also subject to, or actually something we need to look into, is what we call agreements to agree. So an agreement to agree is a case where the parties can't really specify every aspect of the agreement, but want to have a legally enforceable agreement, and they leave some terms that they say that they are going to agree to later. So basically, they want to have every aspect of the agreement. They want to agree on every aspect of the agreement, but they could not reach a full agreement at that point. They agreed on most of things, and they had left some things to be agreed upon later. To achieve this, they basically would be specifying a group of terms or components or pieces of the agreement that they will agree on later. And the question is this enforceable? Now, many modern courts now enforce contracts with agreements to agree, although in the past it was not very enforceable. And they enforce them in the following cases: if the parties are not disputing to be agreed provisions, so the provisions that are yet to be agreed, they basically are yet to be agreed. So if they're disputing those, then the contract, the court will not be enforcing the contract in that case. To be agreed provisions are not really essential. They'd be still bargaining those specific terms. Okay, now another type of agreement is the agreement to negotiate or the agreements to negotiate in good faith. So, unlike the agreement to agree, they basically just have an agreement um, to negotiate with each other. So sometimes an agreement to agree may be seen as an agreement to negotiate in good faith. And the question I have for you is, what is the difference between the two? Agreements to negotiate in good faith, the main difference is that they do not necessarily require the parties to agree. So we can negotiate, and the negotiations can fail, and we just leave each other and will not act on this particular term or this particular aspect of our agreement. So our agreement to negotiate in good faith does not necessitate that we find agreement in the end. So this is exactly what I want to say here. Agreements to negotiate in good faith do not really state the parties would agree. Some courts do not really enforce agreements to negotiate in good faith. However, there's an increasing tendency now to have to enforce them, and the question is, how do they get enforced? And the main method they get enforced is, first, the court could require parties to negotiate in good faith. If the parties do negotiate in good faith but cannot agree, performance is stopped, and they basically any rendered performance is dealt with the principles of something called restitution, where basically any effort that you made is going to be compensated, so that things will be returned back to as if the contract never existed. So that's the concept of restitution. And then, if a party is not negotiating in good faith, sometimes the court could determine what a good faith negotiation would have produced, and they basically will go ahead and award that to the party that was injured by the negotiation in bad faith. Another preliminary writing is something called the letter of intent. And this is a writing that's required in the case where a party wishes to start performance. They want to start performance before an agreement is reached, and they want to ask the party to start performance and give them. So if you, for example, have a contractor, and the owner wants them to start as soon as possible, and they didn't draft the full contract for the construction project yet. Sometimes they may request for performance to begin and until the agreement is reached, and usually the party that's starting performance, in this case the contractor, will need to have some assurance that they will be paid for the work that they're doing during the if the negotiations are not successful. And the letter of intent is usually issued by the party requesting performance, so usually it's sent by the owner in this case, and it will have a directive requesting the contractor to proceed. It will provide a formula for the compensation, or for how much money will be paid to the contractor for the work they'll be performing, and it will basically be a binding agreement even if the parties do not successfully conclude their negotiations. So this is the letter of intent. Memorandum of understanding. A memorandum of understanding is really not a very enforceable document. It's used in cases where we have complicated and lengthy negotiations, and they just indicate that we've agreed on certain terms and still negotiating others. They're different than agreements to agree in the fact that they are everything's still up in the air. So even though we've reached some agreement, at this point, nothing is binding because we're still negotiating, so everything is up for negotiation. They're generally not binding, and if basically negotiations are not concluded, everything else is open, so we can start from scrap, basically scrap everything and start from scratch. And then the purpose is basically to indicate what we call a tentative agreement and aid in basically seeing what remains being negotiated. If the agreed upon terms are reopened, some parties may argue that the other party is not negotiating in good faith. However, still, if there is no contract that is in existence, the party that's negotiating in bad faith doesn't have too much to lose, and basically there'll be very few cases where they'll be able to, or they'll be harmed by their less than good faith negotiation. Facts and mutual assent is the subject of our next video. and therefore I'll go ahead and stop here, and I'll see you in our next video.